So in the last class, we were discussing about strict interpretation with respect to taxing statutes. I think we were in the middle of discussing a few cases. So I'll complete that today and then start penal statutes. So we were discussing about the case by the name Atlas Cycles Industries Limited versus State of Haryana. I think this is the case we were discussing.
Yes, sir. Yes, sir.
Yeah, so in this particular case, the facts are very simple. New areas were included within a municipality, and a provision extended rules, bylaws, orders, directions, and powers to these areas as well, to the newly included areas of municipality. Now the question is whether a notification imposing tax was also deemed to be extended, because the rules, bylaws, orders were also extended. Because it's a taxing statute, it cannot be assumed that by virtue of extension of rules, bylaws, directions, powers, this tax has also been imposed in these areas. For that to happen, it has to be through clear provisions of the law, which is not there, and hence you can say that this is a case of strict application of strict construction in taxing statutes, taxing matters. The next important case by the name Dunlop India Limited versus Union of India. Just a second. So in this particular case as well, you will see a kind of strict interpretation, but strict in what sense? I mean, some aspects of what we had discussed in the literal interpretation has been applied in this particular case. So the facts are like this. So the question is whether VP latex would come within the meaning of the word rubber. So the problem is that VP latex is an artificially created latex, whereas rubber is commonly identified with the rubber made with plant extracts. Now, whether the word rubber has been used in that specific sense or not is a question that the judges had to deal with. So it was held that the natural and popular sense of the term has no ambiguity. So if we are to go by the natural and popular sense of the term, then VP latex would clearly come within the meaning of the word rubber. So it says, and the legislature, while using the term, had this meaning in mind. So they didn't go by the very restricted meaning. Okay, so you can see that when it comes to certain, so that rule of literal interpretation also applies here, that we are to give the meaning which is popularly understood in that in that particular trade or area. So in this particular case, there was supposed to be no such confusion, and VP latex clearly comes within the meaning of the word rubber. Similarly, in another case by the name ACC Limited versus Commercial Tax Officer, in this particular case, we need to understand a very clear distinction between two different kind of provisions in a taxing statute. Now, when we talk about taxing statute, not every provision within a statute is to be interpreted with a strict is to be strictly construed. So within the taxing statute, you come across two different kinds of provisions. Okay, one that is called charging provisions. So charging provisions are the one that impose the tax. Okay, and there are various machinery provisions. Okay, now this rule of strict construction applies only with respect to charging provisions, because through charging provisions such burdens are imposed. So that's the portion which is to be construed strictly. So this rule does not apply when it comes to machinery provision. So in this particular case, the Supreme Court maintained that a distinction has to be made by the court while interpreting the provisions of a taxing statute between charging provisions which impose the charge to tax and machinery provisions which provide the machinery for qualification of a tax, okay, and the levying and collection of the tax so imposed. So only the charging section that imposes charges to the tax is to be interpreted strictly. That was said in a case by the name CWT versus Ellisbridge Gymkhana, 1998. Just a second. And you will find many other cases where this same idea has been held. So in this particular case, it was said that the legislature deliberately excluded a firm or an association of persons from the charge of wealth tax, okay? And the word individual in the charging section cannot be stretched to include entities which had been deliberately left out of the charge. So these entities, okay, firms and associations of persons were not there within the charge of, wealth tax. However, the word individual was there, so it was held by the court that this term individual cannot be extended so as to bring those two entities which were excluded within the purview of the legislation. So that's what had been said, okay. And then it further said that the charging section which fixes the liability is strictly construed, but that rule of strict construction is not extended to the machinery provisions which are construed like any other statute. So the machinery provisions must no doubt be so construed as would effectuate the object and purpose of the statute and not to defeat the same. So this purposive construction applies much more with respect to machinery provision, okay, and not as much with the taxing statute. Taxing statute is to be applied strictly by the literal meaning as we come across. There is one more case by the name Vaidyanath Ayurveda. Let me type it just a second. So this is the case, okay, by the name Vaidyanath Ayurved Bhavan versus Excise Commissioner of Uttar Pradesh. So in this case, certain medicines containing tincture and spirit, etc., were manufactured by the appellant company. Now you know that tincture and spirit contains alcohol, and the appellant was thus asked to pay duties under Medical and Toilet Preparations Excise Duties Act 1955. So you see that where the problem is now. So the appellant argued that the alcohol under the act means pure alcohol, and that since pure alcohol was not used in the preparation of the medicine, no duty could be imposed. So the appellant pleaded for construing the word alcohol strictly in favor of the subject, as it was an interpretation of taxing statute which involved. So the appellant's contention was that, well, go with strict interpretation, and strict interpretation would mean that my product would not come within the purview of the application of this act. However, the court came to a different conclusion. Court said that we go by the strict construction, but by that, it does not matter what is the concentration and what purpose it is used for. It comes within the meaning of the word alcohol, and hence the product would be within the purview of the act. So it said it has a clear and unambiguous meaning, the word alcohol. If a medicine or toilet preparation contains alcohol, it is subject to duties under the act. It is therefore irrelevant whether the medicine contains pure alcohol or some substance which in itself contains alcohol. So that's how this rule was applied in this particular case as well. So we'll take one last case, and there I hope would clearly explain this whole thing. So yeah, this case goes by the name Azam Jha versus Expenditure Tax Officer, Hyderabad. So we are concerned in this particular case with Section 2G of Expenditure Act 1957, Expenditure Tax Act 1957. And it defines dependent. Okay, it says dependent means where the assessee is an individual, his or her spouse or minor child, and includes any person wholly or mainly dependent on the assessee for support and maintenance. Now, what does this mean? So it said that it held that the concluding words in the definition, that is wholly and mainly dependent on the assessee, did not refer to the spouse or minor. Okay, so wholly and mainly dependent on the assessee did not refer to the spouse or minor child, and that the spouse and minor child would be dependents even if they had their separate income. So that was the kind of interpretation that they came to. Separate income, and were not in fact dependent on the assessee. Okay, so it says dependent means where the assessee is an individual, okay, his or her spouse or minor child. Okay, so that's their category, and includes any person wholly or mainly dependent. Now, whether this portion, wholly or mainly dependent, then qualifies spouse or minor or not, said that no, it does not matter. So it was held that wholly and mainly dependent on the assessee did not refer to the spouse or minor. So in this particular case, it was said that it must be remembered that, remember what we discussed earlier, that logic and reason cannot be of much avail in interpreting taxing statute. And that's how strict construction of taxing statutes are done. Anyway, so these are not the only examples. There are many other examples. It's not possible for me to go on discussing all the cases, but I think these are certain examples which will clearly explain what strict construction of taxing statutes means. Now, strict construction of statutes, okay, that rule also applies when it comes to penal statutes. Now, when it comes to penal statutes, the rule applies in a little different way. When we say strict construction, the same rule is followed. When it comes to taxing statute, there is a kind of complete neutrality. Okay, it is neither interpreted in favor of the state, nor is it to be interpreted in the favor of the individuals. Okay, only when it allows for two equally, cogent possibilities, has it been said in some cases that preference should be given to the subject and not to the state. That's the idea. Okay, that depends on judges' ideological position as well. Now, when it comes to penal statutes, the idea is much more clear. Okay, that whether someone, so the idea is that we are to assume that in a state, your liberty, your freedom are protected. Okay, so that is for us to start with. We have to start with the utmost respect for your liberties, your freedoms, etc. Okay. Now, penal statutes, quite, as you know, has a negative effect on the same. Okay. Now, for someone to be denied liberties, freedoms, etc., that has to come within the clear meaning of a statute, of the penal statute. If it does not, then the benefit will be given in favor of the subject's liberties. That's the idea of strict construction when it comes to penal statutes. So there has to be a crystal clear language required to create a crime. Okay. However, at the same time, this rule is something that you have to remember is also subject to another rule that we had discussed. Can you guess which rule this rule could be subject to? Can you make a guess? Am I audible to all of you?
Yes, sir. Yes, sir.
All of you. So just make a guess. All the rules that we have discussed, this rule that we are discussing right now is kind of subject to another rule that we discussed. But we are not at the same time to assume that it will be always taken over by that rule, though. When you make a guess, it's okay even if you make a wrong guess. Let me see if you guys remember. Are you guys there? Make a wrong guess, that's also perfect, no problem. Let me just see if you guys are following what we are discussing here. Saharsh, are you there? Saharsh Dubey.
Yes, sir. Yes, sir.
Can you make a guess? It's very easy, isn't it?
It's not that bad.
Is it
Yes,
literal?
Which one?
Literal.
Every rule would be, yeah. Anyway, literal rule is there, okay? I'm saying that this rule is subject to another rule, okay? So take literal rule out. Almost every rule would be subject to literal rule. So any other rule?
Sir, statutes must be read as whole.
Well, that's general, isn't it? So yeah, do you guys remember Mischief Rule?
Yes, sir.
Yeah, so when it comes to penal statutes, when we talk about strict construction, we cannot at the same time, be so strict that we forget about the Mischief Rule. Mischief Rule also asks us to look at the purposes, okay? So sometimes you have to look at the purpose. So that's why I asked this particular question. So do you get it? Let me explain, maybe this will be clearer to you, okay? So the penal statute rule of strict construction when it comes to penal statute says that we are to go by the clear language, okay? And that's the rule of, literal rule, as you have said, okay? We have to go by the clear language. So there is, the legislature has to draft the legislation properly in order to keep someone within the ambit of the mischief to be dealt with, okay? So clear language has to be there for something to be, for creation of a crime. So a statute enacting an offense or imposing penalty in such situation is to be strictly construed. So that's the broad idea, that it is for the legislature to be careful, okay, while drafting. If it intends to bring someone within the purview of a particular provision of an act, penal statute, then it has to, through clear language, bring that visual within the purview of the act. Now, if it is ambiguous, okay, if it provides multiple interpretations, then the interpretation which protects the liberty of the subject is the one which is to be preferred. That's the understanding, okay? But that does not mean that we lose sight of the mischief rule, okay? That it is subject to the purpose, okay? A statute is to be understood in the light of the purpose, and purpose here would mean that statute was created so as to address a particular mischief, okay? And that cannot be lost sight of either. So both these things have to be kept in mind. So the rule is kind of restricted in its operation. So in the case by the name, just a second. Okay. In this particular case, Askeri Lakshmanan Fireworks versus K.V. Sivarama Krishnan and another, it was said the rule exhibits a preference for the liberty of the subject. As I just explained to you, the rule exhibits a preference for the liberty of the subject, and in a case of ambiguity, enables the court to resolve the doubt in favor of the subject and against the legislature which has failed to express itself clearly. So that's what I was trying to explain to you, that if there is ambiguity in the provision and two interpretations are possible, then the interpretation that protects the liberty of the subject is the one which is to be presumed. The idea is that liberty, freedoms are by default to be, unless they are clearly taken away by virtue of penal statutes. Okay. Similarly, Pollock had said in Attorney General versus Silum. Just a second. That the distinction between strict construction and a more free one has no doubt in modern times almost disappeared, and the question now is, what is the true construction of a statute? If I were asked whether there be any difference left between criminal statute and any other statute not creating an offense, I should say that in a criminal statute, you must be quite sure that the offense charged is within the letter of the law. So, just saying that, well, we no longer adhere to the same idea of distinction between an ordinary statute and a criminal statute. However, nonetheless, points out some distinction here. What is that? That in a criminal statute, you must be quite sure. Okay, so that idea of reasonable doubt. Okay, not just to the facts. Okay, not just from the facts, but from also the application of the law, from the law itself. That sure that the offense charged is within the letter of the law. So that's the idea. So alluding to the same idea that the legislation has to be very clear. Similarly, Lord Asher had said in Tuck and Sons versus Priester. Tuck and Sons versus Priester, okay, an old case, 1887, Queensburn's division, that if there is a reasonable interpretation which will avoid the penalty in any particular case, we must adopt that construction. And if there are two reasonable constructions, we must give the more lenient one. So see what the idea is. Okay, so it's saying that the interpretation that avoids penalty is the one to be preferred. And if there are two constructions and one is lenient, the other one is harsh, then it will prefer the more lenient one. So in the tilt here is always towards liberty. And in the book that I referred to, in GP Singh, the author has referred to this. Okay, author has defined it like this, that in a statute dealing with a criminal offense impinging upon the liberty of citizens, a loophole is found. If a loophole is found, it is not for judges to cure it. Judges will not say that, well, this must not have been the intention of the legislature, and hence we bring the subject within the purview of the application of the act. That's what he's saying. So a loophole, if found, it is not for judges to cure it, for it is dangerous to derogate from the principle that a citizen has a right to claim that howsoever much his conduct may seem to deserve punishment, he should not be convicted unless that conduct fall fairly within the definition of crime of which he is charged. So broadly, see, it is based on certain principles, like the principle of rule of law is very much applicable here. Because if it were to depend on judges, subjective understanding and interpretation, that would go against that idea. So that's the idea. It's based on the rule of law and also prospectivity of law, that I should know the law before I'm, subject to it. So that's clearly the case. And of course, the idea of protection of liberty of citizens. So the interpretation that goes in favor of the liberty is to be preferred to the one that goes against it, if it is allowed, okay, only then. So further, it is said that the application of the rule does not permit the court in restraining comprehensive language used by the legislature, the wide meaning of which is in accordance with the object of the statute. So if it is clear, okay, in accordance with the object of the statute, then obviously judges cannot go and say that, well, we are protecting the liberty. If it is clearly within the purview of the act, then obviously that's what the legislature has intended, and then obviously court will not have much discretion then. Similarly, Lord James had said, but where the thing is brought within the words, and within the spirit, there a penal enactment is to be construed like any other instrument according to fair common sense meaning of the language used, and the court is not to find or make any doubt or ambiguity in language of a penal statute, where such doubt or ambiguity would clearly not be found or made in the same language in any other enactment. So basically, if it is clearly within the purview of the Act, no doubt is to be raised. However, the rule is subject to, as I said at the very beginning, that at the same time we are not to forget that we have the Mischief Rule. If an enactment had been created precisely to address the defects in the common law or any statute law that existed before, a mischief for which that law did not provide for, and from the purpose of the Act you can clearly say that this instant Act had been created to redress that particular mischief, then obviously the judges are to prefer the interpretation that basically effectuates that purpose of the statute. So this interpretation is definitely subject to that, and Maxwell had clearly referred to that. So Maxwell says, the effect of the rule of strict construction might almost be summed up in the remark that where an equivocal word or ambiguous sentence leaves a reasonable doubt of its meaning, which the canons of interpretation fail to solve, the benefit of the doubt should be given to the subject, and against the legislature which has failed to explain itself. But it yields to the paramount rule that every statute is to be expounded according to its expressed or manifest intention, and that all cases within the mischiefs aimed at are, if the language permits, to be held to fall within its remedial influence. So if the mischief which has been addressed is clearly within the manifest intention of the legislation, then obviously in such case we cannot that interpretation is to be preferred, which redresses that mischief. So the rule holds, but it is subject to this mischief rule that we discussed, as has been said by Maxwell. So I hope this explanation is clear to you for now.
Yes, sir.
Okay.
Yes, sir.
So let's look at some cases, and that will make it clear for us. The first case that we look at is by the name State of Maharastra versus Bharat Chagan Lal Ragani 2002 case. Just a second, I will put it there. So the idea is that, if someone comes within the purview of the application of a particular provision of an act, penal statute, it has to be interpreted like that, And obviously, if it is possible, if two interpretations are possible, then we are to prefer the one that protects the liberty. So that's the rule that we discussed. So in this particular case, what had happened was that we are concerned with interpretation of section 15 of Tada Act, Tada 1987, and it refers to certain confessions made to police officers to be taken into consideration. So that's what we are concerned about. And here Rule 15 says, confession recorded is required to be sent to judicial magistrate along with the accused. So what happened in this particular case? So it was, in this particular case, the said section having regard to the object of meeting the menace of terrorists, make confession recorded by a police officer admissible, although the confession so recorded is required by Rule 15, as I just read out to you, to be sent to judicial magistrate along with the accused. It has therefore been held that the magistrate is not obliged, it says confession recorded is required to be sent to the magistrate along with the accused. So in this particular case, it has been held that the magistrate is not obliged to make an inquiry regarding the voluntary nature. It merely says that it is to be sent to the magistrate, So it does not say whether magistrate should make such inquiry. So it said that held that the magistrate is not obliged to make an inquiry regarding the voluntary nature of the confession before sending it to the designated court for such an inquiry would frustrate the purpose of Section 15 in authorizing the police officer to record confessional statement. So these are some kind of special act, okay? So some kind of dilution of those standards are there, okay? And that in itself will not be used to negate the very purpose for which this particular provision has been created. So ultimately, it's a kind of, you can say, strict application of the rule of strict construction of penal statute, okay? So the next important case that we can look at is some important small cases, but we know that when it comes to a strict interpretation of penal statutes, we are to go with strict interpretation. Guys, there is a power cut here, so there's a chance